torture or harassment.
That is why, if I may say, 399 and 402 are differently worded.
ಅಲ್ವೇ ಇದರಲ್ಲಿ
Preparation and attempt.
ಅಲ್ವೇ ಇನ್ನೊಂದ್ಸರಿ ನೋಡೋಣ ಇದರಲ್ಲಿ. My learned friend Millard invited my lord's kind attention to schedule class 3 ಅಲ್ವಾ? Schedule 3 ನೋಡೋಣ ಒಂದ್ಸರಿ.
Whoever attempts.
ಅಲ್ಲ ನೋ Millard, no
Schedule of the act.
Schedule.
no
Constitution office.
no ಇದರಲ್ಲಿ ಗೋಸ್ಟ್
Under the pretext.
ದೇವ probably in Gudiyaman my learned friend might have invited my lord's
Under
under the pretext of
expelling the ghost, assaulting by tying the
assaulting by tying the
Mata,
person with a rope or chain, beating by stick or whip to make the person drink footwear, soaked water, giving chili smoke, hanging a person to roof, fixing the roof.
Under Millard, under project
or
2.
by hair or pluck his hair, causing what is all this?
Different Millard, because what happens Millard schedule has Millard item number 1 to 16.
ಇಲ್ಲ, ಮುಂದೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಮುಂದಕ್ಕೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ,
ಅಲ್ಲ, ಓದೋಕ್ಕಿಲ್ಲ.
ಇಲ್ಲ ಯಾವ್ದಾಗಲ್ಲ. If at all, my lord, at the worst, if we take the entire my lord allegation to its face value as true, it should come within the parameters of 1, 2 and 3.
Please.
Beyond it ಬರೋದಿಲ್ಲ. I'm sure my learned friend would certainly fairly
ಆಮೇಲೆ
concede.
ಬೇರೆನೇ ಇದೆ.
ಬರೋದಿಲ್ಲ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ.
Practice.
ಒಂದ್ ನೋಡೋಣ performing completion. Inhuman evil act and black magic in such of precious things, bounty and hidden treasure, or for similar reasons in the name of such as Banamati, Mata Mantra, assaulting any person, parading naked, or put a ban on his daily activities, or instigate, advise, or encourage committing of such inhuman acts. Ilbarala. Now, my lord, kindly go to 2. To create an impression by declaring that a power inapprehensible by senses has influenced one's body, or that a person has possessed such power, thereby create fear in the minds of others, or to threaten others of evil consequences for not following the advice of such person, or deceive, defraud and deter him. ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು? ಏನ್ ಮಾಡಿದೆ ಅಂತ 1, 2, 3 ಬರೋದಿಲ್ಲ, ಬಾಕಿದ್ರಷ್ಟು ಇಲ್ವೇ ಇಲ್ಲ.
ಬಾಕಿದವರು
ಬರೋದಿಲ್ಲ. ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ, ಇದು ಯಾವ್ದಾದ್ರು 1, 2, 3 ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ ಆವಾಗ 307 ಆಗ್ತಾ ಇತ್ತೋ ಏನೋ, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ 307 ಏನು? ನಾವು ಕೈಂಡ್ಲಿ ಸಿ 380. Yes, alleged 380. Theft of jewelry. When? About 4 years ago. Not today. About 4 years ago, I stole the jewelry ಅಂತ.
mother-in-law's jewelry.
ಕಂಪ್ಲೇಂಟ್ ನನ್ನ ಮೇಲೂ ಇಲ್ಲವೂ ಇಲ್ಲ, ಸರ್ವೆಂಟ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟು. ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಆಯ್ತಲ್ಲ, 3 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಯ್ತು. ಫಸ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಸ್ JNWC, ಕಸ್ಟಡಿ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್. ಅದು ತಗೊಂಡ್ವಿ ನಾವು, ನಮಗೆ ಕೊಟ್ಟರು ಕೋರ್ಟ್ನವರು. Second proceedings was filing a complaint against him for an offense under the 490/80 and 3/4 of the Dowry Prohibition Act. Third proceedings ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I would file a petition against him seeking for a decree of divorce on the ground certain allegations which I have made. ಆಮೇಲೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರು ಸ್ಟೇ ತಗೋಬೇಕಾದ್ರೆ some inaccurate submission has been made stating that he has filed a complaint against me, therefore I have filed a complaint against. No, that is incorrect. I can give you a lordship the dates. Have a look at the dates, man.
No, first petition for divorce is by you.
My complaint was mine, petition was mine, everything was mine. ಅವ್ರದು ಆಫ್ಟರ್ ಥಾಟ್. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ he goes and files a private complaint. In fact, my lord, what the Supreme Court has said is, we have a common notion that under section 468 of the CRPC, my lord, the prohibition is imposed only upon the court. No court shall take cognizance of an offense excepting upon a complaint filed within a period of so and so. ಇಲ್ಲಿ ಥೆಫ್ಟ್ ಏನು ಅಂತಂದ್ರೆ, the maximum punishment that is permitted under the law is 3 years. ಇವ್ರದ್ದು ಅಫೆನ್ಸ್ ಯಾವಾಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ 2020 ಜನವರಿ,
Complaint?
ಫೆಬ್ರವರಿ 2023. ನಮ್ದೆಲ್ಲ ಆದ್ಮೇಲೆ
1 month after the limitation.
ಅಲ್ಲಿಗೆ they can't contend that it is a case that is a prohibition imposed upon the court from taking cognizance. Even a prohibition is imposed upon the policeman from taking the complaint is a law laid down by the Supreme Court.
No. That should not be mistaken. Cognizance can be taken after 10 years.
ಮಾಡ್ಬೋದು.
It is the act of the complainant to file a complaint within
ಇಲ್ಲಿ
limitation.
what is
That is not the law. Is that cognizance ತಗೊಳಕಲ್ಲ, complaint ಮಾಡಕ್ಕೆ 3 years ಒಳಗೆ ಮಾಡಿರ್ಬೇಕು.
period. Well, what the Supreme Court has said is, even when you go before the police, you should be well within time.
Yes.
The period that is prescribed is what the Supreme Court has said.
The complaint is entertained. The court at its own ease takes cognizance after 7 years. That would not absolve the
Alvay.
accused.
Alvay.
It is only the
The policeman
victim.
ought not to have registered the crime at all. Well, that is
is
what the
clear.
Supreme Court has said.
ತಾರಾ ಮ್ಯಾಥ್ಯೂ ಅಲ್ಲಿ ಹೇಳಿರದೆ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಭರತ್ ದಾಮೋದರ್ ಕಾಳೆ ಕೇಸ್ನಲ್ಲಿ this is what the Supreme Court would say in paragraph 10.
No, the constitution bench in Sarah Matthew has clarified this, saying that it is not, limitation does not run on the date on which the court takes cognizance, but
The date
on
of
the
filing
date
of
on
the
which the
complaint.
complainant registers the
ಅಲ್ವೇ?
complaint.
ಅಲ್ವೇ?
Cognizance ಗೂ 468 ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Otherwise, my lord, everybody would contend for no fault or sin on my part on account of some laches negligence on the part of the court. Why should I be
That is
thrown?
true. No, that is
thrown
why
out?
Supreme Court has clarified